Today we're going to be talking about law school accreditation, a topic that's near and dear to my heart. Just to give you a little background on me before I introduce my co-panelists, I am currently a member of the Minnesota Supreme Court and have been for a year and a half. I was appointed by Governor Tim Pawlenty in July of 2010. But before that, for the previous 6 years, I was a tenured professor of law at the University of Minnesota. And I had an opportunity to go through the accreditation process and then the self-study process while I was at Minnesota. I wasn't directly responsible for it, but every faculty member has to do his or her part in making sure the accreditation process goes smoothly. And so this is something that I'm familiar with, although I will admit that my co-panelists are far more familiar with this topic than I am, many of them having lived it for the last 10 to 15 years. But what you'll find, and I think the reason why the Federalist Society asked me to moderate this panel, is that legal education is changing. Costs are increasing, accountability is increasing, technology is changing the face of legal education. And it's my prediction, frankly, having sat on both sides, both as a professor and now as a member of the bench, it's my prediction that we're going to see massive changes in the nature and form of legal education over the next 20 or 30 years. So one of the questions is who's going to be driving the bus? Is the ABA going to be driving or helping shape the law schools and legal education over the next 20 or 30 years? Or are the law schools themselves going to be the ones that are pushing the changes and anticipating the changes that have to come to legal education? So we're going to talk about a variety of things today. We're going to talk first about the role of accreditation. Clark Neily, who I'll introduce shortly, is going to get us started on that topic. We're going to talk about the substance of legal education. For one thing, a lot of practicing attorneys want folks who come out of law school to have a greater number of skills that allows them to ease into and hit the ground running with respect to legal practice. We're going to talk about proposed changes in the way law schools are structured, including a proposal to get rid of tenure, or at least scale back tenure for faculty members. And finally, we are going to spend some time on transparency. A lot of you have probably read recently, New York Times and other newspapers have been covering the fact that there's been some cheating on law school employment numbers, and that's something that we'll talk about in the context of the accreditation process. All right, our first speaker, and the way we'll set this up is we'll spend 8 to 10 minutes with introductory remarks from every speaker. Then I'll ask a couple of questions to sort of get the discussion flowing among the panelists, and then we'll spend some time taking questions from the audience. Our first speaker who's going to get us started is Clark Neily, who is a senior attorney at the Institute for Justice. Clark Neily joined the Institute for Justice as a senior attorney in 2000. He litigates economic, liberty, property rights, school choice, First Amendment, and other constitutional cases in federal and state court. Mr. Neily is also a member of the Institute's school choice team. He's represented parents and children in defense of Florida's Opportunity Scholarship Program and been involved in litigation involving school choice programs in Arizona, Maine, Milwaukee, and elsewhere. So without further ado, I'd like to introduce Clark Neily, our first speaker.
Well, thank you, Justice Stras. It's a pleasure to be here. I want to thank all of you for being here today, and I think this is an incredibly important and interesting subject, and one, to be honest, that I didn't have a lot of personal knowledge about until I was asked to be on this panel. But what I do for the Institute for Justice is what we call economic liberty litigation, challenging illegitimate restrictions on people's ability to earn a living. And what I encounter when I do that work basically are pretextual and unsupported justifications for blatantly anti-competitive regulation, over and over and over again. Just to give you a few examples, the Institute for Justice has been engaged in a pitched battle with the interior design cartel for about the last 5 years, because the interior design cartel thinks you should have to have a license to practice interior design, and sane people do not. Another example, in Louisiana, is the only state in the country. You must have a government-issued license to be a florist. No kidding. In many states, you have to have a license from the government to engage in what I'm sure we can all agree is the very dangerous activity of hair braiding. There's people who just braid hair for a living, African hair braiders in particular, and they're required in many states to have a cosmetology license. The list could go on, but I won't. My point in bringing this up is that even though I was personally new to the accreditation issue, I certainly was not new to the dynamics that I began to see as I read up on the history of accreditation and what is involved. And what I saw essentially was, again, from my perception as a working constitutional litigator that challenges economic regulations that, in my view, are baseless and unconstitutional, is basically an absence of credible justification for regulations that interfere with people's ability to earn a living. And I personally believe that that is very much the dynamic that we have with law school accreditation. That basically it is very difficult, if not impossible, to make an empirical case for it. And perhaps not surprisingly, it appears no one's really tried to make an empirical case for law school accreditation, let alone the extraordinarily detailed and burdensome accreditation standards that I think we're going to be discussing today. I'm going to basically address three questions in my opening remarks, and those questions are: first, should we have a government-mandated accreditation system for law schools? Second, if so, is it good to have one organization, in this case the American Bar Association, have what amounts to a monopoly on that process? And second, has the ABA earned the right to have such an outsized influence on the process? And my answer to those questions is no, no, and emphatically no. And let me start with the first one. I'll just do this very briefly because I really don't think we're here today to debate whether there should be an accreditation process at all, but rather what should the standards look like. But as a libertarian constitutional litigator whose heart is very much with liberty and freedom, I'd be remiss if I didn't at least try to make a case for getting rid of accreditation altogether, and I'll do that by starting by attacking an even higher level premise, which is that we need occupational licensing for lawyers at all. For those of you who are familiar with this literature, the people who have examined the question of occupational licensing from an empirical standpoint to determine whether it is efficacious have generally and almost unanimously concluded that the answer is no. Perhaps surprisingly, I'm talking about even in the professions. Dentistry. There's a famous study on electricians, for example, that when states began regulating electricians, the number of electrocutions actually went up. Why? Because the price of electricians went up and people started doing it themselves, a theme that will become relevant in just a second when I continue with my talk about law school accreditation. So I checked the premise that government licensing of who can be a lawyer is empirically supported in the first place. It imposes massive costs, as we all know, from attending an accredited law school, studying for the bar, et cetera, and for no documentable benefits, at least that I can determine or I can ascertain or anybody else has. But again, I won't spend too much time on that question because I think we're really here to talk about the second two questions, whether we should have what amounts to a monopoly on the accreditation process and whether the ABA has earned the right to the outsized influence that it has. I think the second question is frankly, or the second of my three questions is quite easy. Of course we should not have a monopoly on this accreditation process. Now make no mistake, when we're talking about accreditation of law schools, we are talking about basically a private entity exercising what amounts to government power, because most state Supreme Courts have turned over to the ABA the role of accrediting law schools. They've essentially outsourced the job of determining what law schools will be, graduates of which law schools will be permitted to sit for a state bar. So the ABA really does wield what amounts to a governmental power when it comes to accrediting law schools, because for most people in this country, or at least in most states, you have to go to an ABA-accredited law school in order to sit for the bar. Based on the materials I looked at, it appears to be that there are only 5 states that make an exception to that: Alabama, California, Connecticut, Massachusetts, and Tennessee. But in every other state, you have to graduate from an ABA-accredited law school to sit for the bar. Now, there is one further alternative, and that's how the Institute for Justice actually got involved in this issue to begin with. There are a majority of states where if you have been admitted to the bar in another state, even though you didn't take or even though you didn't graduate from an accredited law school, an ABA accredited law school, then you can sit for that state's bar. So just to break it down, if you were able to get admitted in one of these gateway states, one of the 5 states I just mentioned, where they allow non-ABA accredited graduates to sit for the bar, you become admitted in that state, and it's mostly California. California has by far the most number of non-ABA accredited law schools. So let's say you sit for the bar in California after graduating from a non-ABA accredited law school, you get admitted to the California bar. The question then becomes, can you sit for the bar in other states? In Minnesota, the answer was no up until this year, and we were involved in an effort to change that rule to help Minnesota join the majority of states that allow people who have been admitted to the bar of another state to sit for the bar in Minnesota. And happy to say that Minnesota did, in fact, change that rule very much in the direction of liberty, in the direction of allowing people who have been admitted to another bar to also be admitted to the Minnesota bar, even if they have not graduated from an ABA accredited law school. I don't have to tell people in this room why monopolies are bad, but I'll summarize it. They basically tend to drive up prices, stifle innovation, and basically drive the direction of regulation in a way that is not in favor of the market. In other words, there's a market for legal services in this country, and having a one-size-fits-all accreditation process does not serve that market. People who want to hire a lawyer are not well served by a one-size-fits-all accreditation process. Why? Well, it turns out that the process appears to be, and as best anybody can tell from those who've tried to study this, extraordinarily expensive. Milton Friedman had a famous comparison where he said that occupational licensing often forces people to essentially buy Cadillacs who might be just as happy with the Chevy. And that applies absolutely in this case. The ABA standards appear designed to ensure that every American law school is, in effect, a Cadillac law school, and turns out what amounts to be Cadillac lawyers. Does the market really need that? I think not. If you look at what lawyers, when lawyers get disciplined, which is too rare, they should get disciplined more, but when they do get disciplined, it's not usually for matters of competence at the level we're talking about here. It's not because they failed to appreciate the intricacies of offer and acceptance in the contract, or they didn't fully grasp proximate cause, as I'm sure you all do, hearkening back to your first year torts exam. It's for simple things like they don't know how to file documents on time and they can't keep their own money separate, or they won't keep their own money separate from their client's money. You don't have to have a high-level jurisprudence class. In fact, spending your time in a high-level jurisprudence class is time you could have been spent being taught how to keep your money separate from your client's money and the importance of doing so. But we have an accrediting process that is incredibly focused on churning out what amount to be Cadillac lawyers, people who can speak to you ad nauseum about esoteric principles of law, but may never have filed a single pleading before in their lives or participated in an actual commercial transaction. And this is, to me, a serious mismatch between what the market actually needs and what law schools are turning out. And I think that the ABA plays an unfortunate role in maintaining that disconnect. All right. Let's take just a couple of standards to use as examples. Under the current ABA standards, one of the things that law schools have to meet in order to be accredited is they have to have an adequate law library. And an adequate law library is one that contains a certain number of volumes of hard copy books. For those who've never seen one, this is an actual collection of loose leaf pages, and there's words printed on them. And it sits on a shelf. And if you need to read what's in that book, you reach up, pull it out, open it up, and there it is. For those of you who actually practice law, of course, this all appears on your computer. And it's faster and more efficient, and much more important that you know how to do that kind of research. And yet the ABA won't accredit a law school unless it has a library with a certain number of physical volumes. And I find this incomprehensible if the true purpose is to churn out minimally competent lawyers, but entirely understandable if the point of accreditation is to protect the sunk costs of existing law schools who have gone out and purchased incredibly expensive libraries. How much are we talking about here? Well, no one really knows, but estimates run as high as $1 million a year to maintain a physical law library. My goodness, what could that money have been spent on? Skills classes? More outreach? Teaching people how to actually practice law? All of those things. These are all opportunity costs, and the list goes on and on. Trust me, I'm just picking on the law library requirement for now. But it's indicative, unfortunately, of, I think, again, a kind of a monopolistic mentality that is focused on churning out not competent practitioners, but Cadillac practitioners that the market doesn't need. Or the market needs them, but believe me, the market will be supplied with them. There are certainly law schools in this country whose reputation depends on churning out Cadillac-level lawyers, and that won't change whether we have accreditation or not. A couple of final points. One of the things that most struck me when I was getting up to speed on putting together my talk today was the utter lack of empirical analysis in this area. So there are all kinds of assertions that are being made about what does a law school have to have in its curriculum. What are the necessary teaching requirements? What are the necessary faculty terms and conditions of employment and so forth and so on to turn out minimally competent lawyers? And as far as I can tell, none of those standards have been subjected to any sort of empirical analysis or any meaningful cost-benefit analysis. And this is strange because in any endeavor where we were serious about getting a good match between regulations and outcomes, that's the kind of analysis we would do. Now, fortunately, we're getting to a point where we can make those kinds of comparisons. As I mentioned earlier, there are pathways, too narrow in my view and too few, but there are pathways now by which graduates of non-ABA accredited law schools can be admitted to bars, and we are going to have the ability to start tracking them and determining, are they any less competent than students who graduated or lawyers who graduated from ABA accredited schools? Do they have any greater number of disciplinary problems? Are they failing to appreciate the esoteric aspects of law practice that are taught in America's top law schools, like offer acceptance, proximate cause? I don't pick on those on purpose. And I think the answer is going to turn out to be no. And if it is, the question then becomes, should that matter? Should we go back and reconsider everything that we are being told about the necessity of having gold-plated legal educations, or should we perhaps stop and consider, is there a more effective, a more fair, and a more market-oriented approach? And I think the answer is emphatically yes. Thank you.
Thank you, Clark, for that stimulating discussion. One thing that I forgot to mention on the outset, but all the panelists asked me to do so, was that because we want to have a frank discussion about this, all of our panelists have various affiliations, including myself, and none of the opinions expressed here necessarily reflect the opinions of who they're affiliated with. Our next speaker is Dean David Yellen. He's been Dean and Professor of Law at Loyola University Chicago School of Law since 2005. From 1988 to 2004, he was on the faculty of Hofstra Law School, holding the Max Schmiertz Distinguished Professorship and serving as Dean from 2001 to 2004. His major areas of expertise are criminal law, particularly sentencing and juvenile justice. And one of the reasons we asked him to be with us today is he has extensive experience in law school accreditation work. He served on the Standard Review Committee of the American Bar Association section on legal education since 2006 and has chaired numerous accreditation site visits. He's also chaired the ABA's New Dean's Workshop and the Dean's Mid-Year Workshop. So without further ado, we will hear from Dean Yellen.
Thank you very much. I want to also, as Clark did, start by putting things in a perspective, rather than diving into the weeds of accreditation issues. I have to say, I wasn't expecting nearly this size group until I learned that you get professional responsibility CLE credit. So I well understand that you're not interested in the nuances of any particular standard, but more in big picture stuff. So let me begin this way. Legal education has changed a lot in the last 25 years. The biggest change, I would say, is how much more market-oriented and market-driven we have become. I assume that's a message that resonates with this group. I'm not a member of the Federalist Society, but I'm happy to be here. But we have become much more market actors, and the biggest factor in that has been U.S. News rankings. But there are many others as well. And this market-oriented approach has had many very dramatic effects on law schools, some very positive, some very negative. On the positive side, for example, I would argue that we actually provide a much better education now to our students than we did 25 years ago. Partly in order to compete for students, to get them to come to my school as opposed to, Tom or Ann's school or anybody else's school. We've offered more and more programs. We have become way, way better at experiential learning. A much higher percentage of students now have a clinical experience or some other experiential learning that serves them well in their careers. And those things have been driven a lot by market forces. On the negative side, for example, a really terrible result of U.S. News and all the related forces is that scholarship spending has shifted almost exclusively from merit-based aid, meaning chasing students with high LSATs and GPAs, away from need-based aid. And that's a really unfortunate market-oriented development. It's also, and we'll come back to this later, I'm sure, it's also the U.S. News influence has led to some really bad behavior. In the news recently, the University of Illinois admitted that they had been lying about their LSATs in order to prop up their U.S. News rankings. Last year, Villanova Law School admitted the same thing. And those things just wouldn't happen without U.S. News rankings. Now, we were able to do all of this, do much more, because we've been spending more and more money over the last 25 years. Tuition has been pretty easy to raise for much of that time because of the good job market through most of that time period and the availability of federal student loans. And so that's enabled us to hire more faculty, expand our programs, and do all of those kinds of things. That era is pretty clearly at an end. For state-funded law schools, funding is drying up from the legislatures. For all of us, law schools, we're confronted with a job market that is dramatically different than it was 10 years ago. And the signs are that these are fundamental long-term changes, not just brief economic blips. So against that backdrop, what's the proper role for ABA accreditation? Unlike Clark, I don't believe that the practice of law should be deregulated or that there should be no accreditor of law schools. I think on balance, both of those things do more good than harm, but that's a separate subject. But I do agree and believe that the current standards are far too intrusive and stifle much needed innovation. And I say that as a law school dean, also as a member, as the Justice said, of the ABA Standards Review Committee, which is in the process of making recommendations about changes that may take place in the standards. Now, as to the ABA standards, it's important to start with a philosophy of accreditation if you're going to be an accreditor. And there's pretty broad agreement that the core function of the ABA standards is to ensure that each school has a high-quality, rigorous educational program sufficient to prepare students to enter the profession. So sort of a quality assurance function and a consumer protection function along with that. So to me, the question that every standard, existing or proposed, needs to be measured against that philosophy. Is this standard reasonably necessary to ensure a quality program of legal education? If it is, I think the ABA is correct, and despite what Clark says, I don't think most of this is subject to empirical analysis. I think it mostly has to be based on experience, which is why I think it's important to have legal educators involved in the accreditation process. Right now, the ABA accreditation function, each major body within the ABA, it's all done by volunteers, and half of each group, whether it's the council, which is the governing body, the Standards Review Committee, or the Accreditation Committee, which is the adjudicatory body, in each case, half are legal educators and half are not legal educators. So it isn't quite fair, I think, to say that it's a monopoly of only self-interested people. But I think that's the question you need to ask. Is it reasonably necessary to ensure a quality legal education? Now, let me mention a few of the things that the ABA is currently considering changing about the standards and talk about how that reflects on this overall philosophy of accreditation. In one area in which the ABA is considering further regulation is what's known as student learning outcomes. The ABA standards have traditionally been very heavy on the input side. So you have to have, as Clark said, an adequate library. Although, as an aside, he slightly misstates the nature of the standards. There is no standard about the number of books you have to have. It does talk about specific pieces of a collection you have to have, but not number of books. But I agree that the library standards are too intrusive. But it's an example of an input standard. On the output side, the only thing the standards have really looked at in the past has been bar pass results, which will certainly remain an important part of the standards. The move to student learning outcomes is to simplify it, is a proposal to require schools to do some strategic thinking about their programs of legal education, to identify what they want their students to learn, to look at their curriculum to see how they promote that learning, to assess student learning in a variety of ways in addition to final exams, and then to step back and assess whether the school thinks it's been doing a good job of achieving its own goals. In principle, I think it's pretty unassailable. In practice, it has a lot of risks because other disciplines that have gone in that direction have sometimes become highly bureaucratic with these complicated rubrics that school check the box thing. So I'm generally in favor of this direction, but I'm personally very cautious about it because of the risks. But I think in the big picture, it's a legitimate undertaking for the ABA to be saying, should we have stricter standards about what has to go into the education of our students? For example, personally, I would favor a requirement that every student has to have a live client clinical experience before graduating. It's very expensive. It would have to be phased in. But I think, it's kind of absurd that you can become a lawyer without ever having represented a real client in your life. That's one category of one of the big ticket items that our committee has been considering. The most controversial one is a proposal that the Justice, again, I tinker with your words, it's not a proposal to do away with tenure, it's a proposal to remove from the standards a requirement that to be accredited, a school has to have tenure or tenure-like protection for most of the faculty. And I'm very much in favor of that change. I'm in favor of tenure, and I think it does more good than harm to have tenure, but I don't think it's a legitimate exercise of the ABA's quasi-governmental function to say that if you want to start a new low-cost law school and staff it in a different way than traditional law schools are staffed, and not have a scholarly agenda as part of why your school exists, and other things that are required by the standards. I think if you can meet the requirements of a high-quality legal education whose graduates learn a lot and pass the bar, you should be allowed to operate that law school and have its graduates take the bar exam. Personally, I wouldn't want to go to that law school. I wouldn't want to teach at that law school. But I think such a law school should be allowed to exist, and under the current standards, because of the rules about security of position, that's not allowed. Now again, tenure, I'm not someone who thinks we ought to detenure the faculty. I understand there are costs to tenure, but academic freedom has served our higher education system extremely well. I just don't think it should be uniformly imposed on each and every law school around the country. How much time do I have? A couple minutes. Okay. The third thing I wanted to mention is the issue of transparency. And this hasn't been very controversial. This has been working the way through our committee for a while, even before the New York Times did a really despicable series of articles, and which are very one-sided and unnuanced. But law schools have not done a good enough job at disclosing to their students what the employment outcomes of their graduates have been. Some of our schools, and I take pride in the fact that my school is one of these, has gone way beyond the ABA requirements and made public on our website all kinds of information about types of jobs and salaries and temporary versus part-time jobs and all of that. Some schools have played fast and loose, and we're in the process of changing those rules so that that will be much cleaned up. This is a problem not just of law schools, but throughout higher education. How many PhD programs disclose to people enrolled in those programs what percentage of graduates get good teaching jobs in universities? How many architecture schools, et cetera? So we're in the process of cleaning up that part of the mess that we're in. But so basically my message is I think there is a proper role for ABA accreditation. You'll hear in a minute from Tom and Ann, who have a rich experience with the AALS, the Association of American Law Schools, an organization that I'm part of as well. I think it's entirely appropriate for a membership organization like the AALS to have higher requirements for membership in it than the ABA does for accreditation allowing you to operate. And I think that's part of where we disagree on whether there ought to be a distinction between what the ALS does as a voluntary membership group and what the ABA does as the mandatory accrediting agency of all law schools. Well, thank you.
Thank you, Dean Yellen. Our next speaker is Professor Tom Morgan, who is the Oppenheimer Professor of Antitrust and Trade Regulation at the George Washington University Law School since 1989. He served as Dean at Emory University School of Law and on the faculties of Brigham Young University and the University of Illinois. Professor Morgan has taught and written in the field of professional responsibility for quite some time. And in 1990, he served as the president of the Association of American Law Schools, the organization which Dean Yellen just referred to. He's also a longtime member of the Federalist Society and serves on the executive committee of the Professional Responsibility and Legal Education Practice Group. Professor Morgan.
Thank you, Justice. I appreciate the opportunity to be here, and I appreciate the other panelists' participation in this topic that I think is one that the Federal Society ought to, Federal Society members ought to have an interest in. I appreciated Clark Neely's presentation about the dangers of licensure regulation and monopoly. These are areas that I've spoken about for many years. I agree with him in philosophy, but I think it's important for us to understand that the application of those concepts to the issues we're talking about is a lot less than might appear. We are well past the days when the system of licensure in the legal profession has artificially limited the number of lawyers. When I came into practice of law in the mid-1960s, there were fewer than 300,000 lawyers in the United States. Now there are well over 1 million lawyers. We've more than tripled, almost quadrupled the number of lawyers in the last 40 years. That isn't to say that that we shouldn't be concerned about the cost, the barriers to becoming licensed. It is to say that the days of monopoly limitation on the number of lawyers really is behind us. I think almost anybody who's tried to measure it would reach that conclusion. Further, to talk about ABA monopoly of the accreditation process, I think again is excessively argumentative. The question, the fact is, the requirement of licensing, becoming licensed to practice law is imposed by state Supreme Courts, federal courts all over the country. You can disagree with that, but it is the monopoly of the profession that is created by governmental institutions, the Supreme Courts, that we're talking about here. The ABA happens to be the organization that each of the states has accepted as sufficient to allow a certification by the ABA to be sufficient to take the bar in any state in the country. If each of our law schools had to qualify under the accreditation standards of, let's say, 25 different accrediting agencies, so we'd break down the monopoly, but each of us had to be visited by all of these different organizations, I don't think, in order to satisfy the desire of our students to take the bar in states around the country, I don't think the system would be improved. If anything, I think it would be reduced in quality. So while David Yellen and I may disagree as to particular ABA standards, there isn't any serious doubt that the desirability of having a uniform, a common group who is responsible for conducting the accreditation process, that one should not be a significant issue for us. Third, it is clear that legal education is going to change. It has to change. It has to change in part because the world is changing and the world of practicing lawyers is changing. We've already spoken about the number of lawyers, but globalization and global competition from lawyers around the world is affecting the practice in this country. As many of you know, Great Britain and Australia have moved to make significant change in their regulation of lawyers. There are multidisciplinary organizations now in both countries that will be practicing here in the United States soon. The General Agreement on Trade and Services is a little behind schedule, but we're moving into a worldwide practice very quickly, and again, we've got to adjust legal education to respond to it. Issues of technology, the effects of technology, all of these things are impacting legal education, in addition to the breakdown of unauthorized practice of law restrictions. Some of them are not breaking down formally, but the fact that so much legal work today is done for corporations, directly or indirectly, means that the corporate general counsel's office can largely elect whether or not they're going to have work done for them by licensed lawyers or by non-lawyer organizations. As many of you may know, there are a number of such organizations now doing everything from response to discovery requests to all kinds of other tasks within organizations. In short, law schools, if they're going to produce people who are going to be able to add value to the organizations that they serve, are going to have to adapt to what those organizations need. The question then becomes, how are those changes going to occur, and what is going to be left of the system? One of the key reasons I think it's important for members of the Federalist Society to want to think about these issues is that there really is a rule of law component to legal education. That is to say, one can imagine the practice of law simply as being performing individual kind of modest tasks. And yet, traditionally, there has been an important role in this society for lawyers who thought seriously about questions of the structure of government, the importance of freedom, the relation of the individual to government, and those are issues that are at least of not modest significance to many members of this society. Indeed, if you look back on the development of the Federalist Society, much of it has taken place within law schools. I've been to a lot of these meetings, and we spend a lot of time criticizing the law schools, and they're all places where our views don't get heard. But the reality is, they are being heard. They're being taught. They're being understood increasingly, and it has been in the process, the milieu that permits free discussion, free debate, and expression of ideas that all sorts of new insights, some powerful, some good, some not so good, have been debated over the years, but it's important, I'd suggest to us, to be concerned about what is left after the changes that we're talking about. David Yellen, I think, was correct in not trying to get us into the weeds of the accreditation issues here, but to make a very broad statement of what I think the debate is. From the point of view of several of us, as we look at what the total package is that is coming out of the ABA, it is excessively deregulatory. Essentially, the content requirement would be something like a 2-hour course in professional responsibility, 2 courses in legal writing, and 1 course that requires you to integrate practice skills with substantive law. It requires, the ABA's requirements would be still a 3-year law school program. But after those initial basic requirements, it is basically any direction you want to go. Some of you may have followed the Truth on the Market blog debate a while ago, in which some people were talking about issues of whether or not law school should be all finance theory, for example. I'm not one who opposes finance theory as part of the training of a lawyer, but the idea that we would take a physics department and call it a law school, as long as it had a course in legal writing, is not to me an appropriate way to think about legal education. My initial presentation is not the place to try to deal with all this. As David said, part of the proposal from the ABA is each school will define its goals and then will assess whether it has met its goals. I think you can estimate what their judgment will be at the time of each accreditation visit. But as somebody who, like David, has been on a number of inspection teams, I don't know how an outsider is going to be able to evaluate the legal education program of a school that has defined its own direction that fully. This, in short, is the debate as I see it this afternoon, and the discussion as I see it, because I hope you will all participate in the discussion. Change is going to happen. Is it going to happen positively? Is there going to be a common core to legal education? My current slogan is core plus more. That is, to be a law school, you have to have a core. I think a much more theoretical core than perhaps some of the ABA, studies that have led to the ABA action. But beyond that, then, schools should differentiate themselves. They ought to compete. If it were up to me, we'd give a degree after 2 years, and then the 3rd year would be elective. But that's the range of issues we're looking at. And I think they're serious issues, and issues that I hope will intrigue you and that you'll become involved in. Thank you.
Thank you, Professor Morgan. Our final speaker is Professor Ann Shalick. She's a professor of law and Carrington Shields Scholar at American University, and she started and directs the Women in the Law program. She teaches family law courses, jurisprudence courses, and various clinical courses. Within the clinical program, she started and teaches the Women in the Law Clinic, has developed the Domestic Violence Clinic, and helped start and taught in the Intellectual Property Clinic. She writes and lectures extensively about gender in the law, clinical education, and family law. Of particular relevance here, she has participated extensively in curriculum development and law teacher training. She serves on the executive committee of the American Association of Law Schools and the AALS Special Committee on ABA Standards. She's chaired the AALS Committee on Professional Development and frequently serves on planning committees for AALS conferences on clinical education and on other committees dealing with curriculum, research, and professional development. We can now hear from Professor Shalick.
Perhaps my biography explains something about how the dichotomies in this debate don't quite fit. I teach jurisprudence, and I've started 3 different practical skills courses, clinics. So the vision of legal education that I think is implicit in what Tom Morgan was talking about and is now subject to debate in the process of the ABA review of its own accreditation standards is what is the role of accreditation in both reflecting and guiding, both of those, what we as a society expect of our law schools in their role as training lawyers for not just the practice of law, though you can tell from what I do that I care about that a lot because I spend a lot of time training students to do that well and training teachers to teach that well, but also roles, fundamental roles in our legal system more broadly and in shaping it, and in our government. And the role of lawyers there is critical to our thinking about what legal education should be about. The second point there is to reiterate a point that Tom Morgan was making, is that this is in enormous flux these days. That the legal profession is in enormous flux, and so legal education is in enormous flux, and therefore it's been an incredibly exciting time for us, as well as a time where we faced many difficult issues. The assumption of almost every accreditation regime and the fact that courts require some sort of accreditation to admit lawyers to practice is that we expect more from our lawyers than passage of a bar exam. Perhaps some of you remember fondly your bar preparation courses and what you retained from those bar preparation courses. I have a daughter who just went through the process in California, and I have students who go through it all the time. And while many people find it important, and I was involved in drafting various sections of the bar exam when they moved to a performance test, so I appreciate many of its functions, but our notion of legal education is that more is required in order to be a lawyer in our society than bar passage. And for the last century or so, legal education has essentially been the source of providing what that more is for the legal system, for the legal profession, for clients who are out there, and I think to not be too ethereal about it, for the role of the rule of law in our democracy. So what I'm going to do is take from this broad introduction a few of the issues that are in front of the ABA now in its review of its standards to explain why I think it is important to maintain a vibrant, dynamic accreditation system rather than a minimalist accreditation system. I'd normally begin with the content of the legal education. I think Tom Morgan has put enough on the table for our discussion, so I will move on here. I'll focus instead on the who should have responsibility for that. Who should shape? Who should have decision-making authority for the content and the pedagogy of any program? And I agree with David Yellen that both of those questions have become, over the last 25 years, much more responsive to the market. To the market if you mean the legal profession, to the market if you mean students coming to law school, to the market if you mean the broader society, which is concerned about what our lawyers do and why they do it and what the ethical practice of law means. So for the who, One of the major debates in the current standards is what should be the balance of responsibility here. In our current standards, it's clear that that responsibility is shared between the dean of a law school and the full-time faculty of that law school. Under the proposed changes, while both of those bodies retain responsibility, I think we could all agree, without getting into the details of it, that there is a shift away from the notion of a full-time permanent faculty having responsibility for these fundamental decisions, not just for who teaches what class, but for these fundamental decisions, and a dean who is increasingly in a model of a CEO of an organization. And that's happening for reasons outside of legal education, much more broadly in higher education. So given that shift, I want to make an argument for why vesting this responsibility, continuing to heavily invest in a full-time faculty with a commitment to the project of legal education is an important one for all of those bodies that rely upon good lawyers and responsible lawyers and ethical lawyers. One is expertise and commitment. A full-time professoriate whose job it is to be expert in their fields and expert in the teaching of their fields, which are two different subjects. If you've ever known a law student come out of a class with a professor who knows the subject very well and can't teach it very well, both of those are important, and those are lifelong, difficult endeavors. The legal system is complex, as we know. Legal work requires judgment, discretion, contextual decision-making. And we know in the legal system, as this whole program shows, it's filled with contested domains. Answers are not simple, that there are multiple perspectives that people bring. So that we want a group of people in our law schools, and we want to require law schools to have a group of people who not only know their subjects, but understand the debates about the subjects, can generate new ideas about the subjects. And this is what Tom Morgan was saying about one of the roles of the Federalist Society, has been to generate those new ideas, to generate critical perspectives, and to understand them both as abstract matters and as intensely practical matters, that they matter not just as matters of abstract debate, but the way any given regulation looks, how you advise any given client, how you balance competing concerns when you're talking with somebody, how you assess risks and benefits. All of these are complex judgments, and they are changing every day. And so what we need are the skills not just in what the legal system looks like now, but what it will look like 5 years from now, 25 years from now, and in a globalized world. So that commitment, that assurance, yes, we should have more empirical study of how we achieve lawyers who do that. But a pretty good proxy is having a pretty good faculty that spends its life, then they spend their life thinking about, talking about, debating about, and yes, writing about these matters. Whether that writing be about how you counsel a client or how the healthcare law should look at this moment and everything in between. Finally, I think that this system of accreditation in requiring that kind of a faculty as not everybody, but as the core decision-making faculty, needs people who have a security of position, not just because of their own academic freedom, that you are protected in the ideas that you have that are controversial, or that you are part of a community in which people have controversial ideas and feel comfortable sharing them, but so that you can participate effectively in the debates in that organization. So that if you care about students being trained in the practice of law, you are at the table to argue to your dean and to the rest of your faculty about why that matters, how it should be done, what portion of the costs of your institution should be devoted to it. Not that those matters should be governed by accreditation, but that the people who decide those should be able to be at the table. And our accreditation system up till now, and I will end with this, has done an amazingly good job at fostering rather than stifling innovation in this area. I will take practical skills training, you could take globalization, you could take many other issues. There have been many forces pushing law schools toward increasing concern about having lawyers be ethical, responsible, practitioners who understand complex subjects like problem solving in worlds that are changing. But the accreditation process has also played its own role by requiring tenure and secure, or a tenure-like security of position for people who do that work. They have assured that that is part of our legal education system throughout the country. Not only in a few Cadillac law schools, but it is available to any one of these people who wants to go to many, many of these seats that are available in legal education now. Because it has not been, as Tom was talking about in terms of the profession, the number of law schools has proliferated. So there are now more seats in law schools than there are takers of the LSAT exam. So that this kind of innovation has been spurred on by an accreditation process that has told us that people who should be at the table in making these decisions, the full-time faculty with security of position, can help to shape a legal education regime that has produced scholarship, that has produced sophisticated teaching about these matters, has, as I encountered in developing what it means to have an intellectual property clinic that does litigation policy and transactional work around copyright, patent, and trademark issues, what that means to have students doing that work, to have the people do that well at the table of legal education is a project that has been fostered by our accreditation standards, and I fear, as does Tom Morgan, that in the what I think is excessively deregulatory instinct of many of the proposals would move away from that to something like one skills-based course, which could be, how do you conduct a good cross-examination? When most of our lawyers will never conduct a cross-examination, good or bad. And I care that people do good cross-examinations if they're going to do it, but our program should be aiming higher for a legal profession that's going to serve a critical function for many of our publics.
Thank you, Professor, and thanks to all of our panelists for insightful comments on an issue in which they're all very familiar, and so I think we've all benefited from their expertise. We're going to move to questions shortly from the audience, and I want to have time to do that. But I want to ask a question which is sort of the elephant in the room, which is, you know, I graduated from law school about 12 or 13 years ago, and my alma mater, the costs of that education are about 3 to 4 times what it was when I went to school, and that's just a little more than a decade. I think that the cost, personally, looking from the outside, and I thought this when I was a professor as well, that the velocity of the increase in costs of legal education is unsustainable. And in fact, I think one of the greatest challenges will be how do we find greater efficiencies in law schools so that we can keep the costs more constant for students. Now, Clark brought up the point that the ABA accreditation process has been more concerned with inputs rather than outputs, and I understand that because objective criteria like inputs are easy to judge. Like, you know, do you have a library that has a certain collection. That's an easy thing to judge. But a lot of these accreditation standards have made law schools more expensive, or at least arguably more expensive. So what should be the role of the ABA accreditation process in improving efficiency and decreasing the cost of education? And I'll open it up to anyone who wants to answer, but we probably ought to keep our comments to just a couple of minutes each.
If I may, I'll start. I think the number one thing the ABA could do in this regard would be to adamantly support the creation of non-ABA accrediting bodies and paths, so that we heard about the importance of experience. Great, let's get more experience. Let's get the experience of organizations that maybe would be interested in accrediting law schools that are turning out graduates who have been taught to be competent, if not intellectual, lawyers. So, for example, we heard about the importance, or the importance to the ABA of full-time faculty. That's basically code for having more full-time law professors than practitioner instructors. I have to really challenge the idea that a full-time law professor is necessarily a better instructor of legal knowledge than a full-time practitioner, or a practitioner who also teaches at a law school. But that's an assumption that has been made and not verified empirically. So I think that's the kind of experience that we need and we could benefit from if we had more organizations in the accrediting business. And I would also add, just by way of finishing, that I think the stakes there are remarkably low. I've been in the hiring business for elite law firms that I've worked at for 16 years, and I'm absolutely convinced that it's virtually impossible to know at the front end whether somebody's going to be a good or even an ethical lawyer. You only find that out when somebody begins practicing law, and anything else is a fantasy. What the ABA, I think, could do to support more the actual consumers of legal services is to be very aggressive about removing lawyers who have shown habitually that they are either incompetent or unethical. And as anybody who's read the literature knows, the consensus is that there is not nearly enough policing of our own profession in that regard. So I think those are two ideas of things that the ABA could do if it were really serious about increasing the quality of legal services to the consuming public.
Well, I believe your question was about cost issues, and law school is too expensive, both because some standards impose unnecessary costs, and also because we're all competitive actors striving for greatness and prestige in a competitive marketplace. So even if all of the ABA standards were removed tomorrow, law school would still be too expensive because of things like, we've significantly reduced teaching loads over the years for tenure-track faculty in order to give them more time to do scholarship, to build our scholarly reputations. And that's not standards-based at all. That's the drive to be seen as better. And that's going to change because of economic forces. In terms of the standards, I think we've highlighted a few of them already that could be changed and reduce costs. I think the library standards are kind of a joke. Even though I disagree with Clark's characterization of them, I think in this era, you need virtually no standards about library and just judge schools on whether they're making the information resources necessary to their students. I also completely agree with Tom that it's time to experiment, at least experiment, with the idea of 2 years of legal education followed by a year of apprenticeship. The standards allow you to do law school in 2 years, but only if you cram in 3 years of work, and therefore every school that's done this has charged 3 years of tuition into 2 years. So those are a couple. And third, I'd say we should be more liberal in the use of distance learning.
Yeah, we all agree that costs need to come down. One of the things that has been interesting, though, is that the chief driver of costs these days has seemed to be U.S. News rather than accreditation standards. The GAO did a study of this a while ago, and it confirmed what I think anybody in the system would have told you, that the part of the way you score higher in U.S. News is to show you spent more than your competitor. Any system that we blame the ABA and accreditation standards for a lot of what's the silliness going on in legal education today, but as David has said, and he's absolutely right, this is driven by much different sources to a great extent, none of which says that we ought to have standards that excessively increased costs.
This is an area where we do have empirical research, and the standards are not largely responsible for this. And U.S. News, if you stood in a faculty mailroom around the time that U.S. News ballots go out, the number of brochures, very slick brochures that come to you from every school in the country that go straight into the trash is astounding. And that's a minor one. A major and more troubling and important one is something that is, in terms of transparency, totally invisible to the public and to all of us, even at a law school, which is the discounting of tuition. That in order to get students at key points in your admissions process with key credentials, tuition is discounted. It is a misnomer to call these merit-based scholarships, because if you looked at a class at the end, you would not see the people with the highest predictors getting the most money, assuming that you believed in a merit-based system of scholarships rather than a need-based system of scholarships. It doesn't work that way. You would look at key decision moments, and people who a school wanted, let's say off of a waiting list at a given moment, who are clearly not the people with your best predictors, are going to get big discounts in tuition in order to come to my school rather than Tom's school. It happens across legal education, and it is a major cost driver at the moment and a major barrier to transparency. It doesn't help students who can't really negotiate in any systematic, sensible way, and it really benefits almost nobody. And that's what the market driven by U.S. News and World Report has done to us. This is not a problem of the accreditation process.
All right, thank you. Let's move to some of the questioners over here.
My name's Paul Salamanca. I'm at the University of Kentucky. I have 3 questions, and I think I can state them pretty quickly. First, the ABA or the AALS. In other words, pick your accreditor, so you wouldn't have to have more than one visit every 7 years. And finally, and this goes to the ABA's argument that it's not a monopoly because it's been identified as a monopoly by the Supreme Courts of the states. If the Supreme Court of a particular state were sued for antitrust because it requires ABA accreditation, would the ABA refrain from intervening on the ground that it doesn't really want to be a monopoly?
Like every good law professor, that was giving 3 questions. We'll try to answer at least a couple of them. Anyone in particular want to answer them?
The Federal Society probably would not be able to be an accreditor unless the state Supreme Court accepted it as such. And to take your second question, yes, they could. The state Supreme Court could say the Federal Society will be the only or one of several possible accreditors. I'd suggest to you the Federal Society today can be a rater. That is, if you have standards that you want to apply, we have standards we want to apply, you're welcome to do that and be an alternative U.S. News. That's what we need. What we need is our other people to establish standards other than some of these crazy U.S. News standards. In terms of the the antitrust point, there have been decisions. The state Supreme Court is a state governmental agency, and its decision to select the ABA or anybody else as its accrediting agent, or agent for information at least, is immune under the Parker and Brown state action exception from antitrust liability.
I'm Roger Pilon, a non-tenured scholar at the Cato Institute. My question is for any of the 3 non-Clark Neilys. It strikes me that you're all, you have a great affection for the status quo. As you doubtless know, Milton Friedman, whom Clark mentioned, thought that licensure should not apply even to the medical profession. What struck me also was that none of you asked the simple question, what would the world look like if we didn't have this accreditation licensure regime? We all know, for example, that pro se argument takes place before the court, and the world continues. What we do see, however, is perhaps a shortage of lawyers. Tom said there's no antitrust problem because we have over 1 million lawyers. How do we know that's enough? Middle-class people today cannot get affordable legal representation, and even well-to-do people can easily be broken financially by legal representation. It strikes me that we could have, as Clark suggested, multiple accreditation organizations of a private nature that would, as in the old days, license people who read law, who apprenticed in the law, and could practice before the courts, having been certified by multiple agencies, and a lot more Americans could then afford access to the courts. What say you?
Well, just a quick question and response. Would you also do away with the bar exam? So basically anyone who wanted to practice as a lawyer could just hang up a shingle.
You betcha.
Okay, so that's certainly an intellectually coherent, defensible position.
Well, thank you.
But, you know, the three of us are the wrong people to make that argument to. Make that argument to David and the other state Supreme Courts. In fact, I think that over the next 10 or 15 years, you're going to see some of the functions that lawyers only can do now to be deregulated. I think just like with physicians' assistants can now legally do some things that doctors only used to be able to do before, I think it will come and is the right thing that simple wills and other certain things that only lawyers can legally do now, some state will say, you know, we think you can get a easier path to do simple wills or other things like that. I think that's fine.
But you folks repeatedly protest the unauthorized practice of law.
Well, I don't. Roger, you're conflating you're conflating several things. You're conflating the occupational licensure, which is done solely at a state level. None of us have anything to do with that. And then the accreditation function, which the states delegate to the ABA, and there are dozens and dozens of volunteers who have no financial interest in it, who just do it because we believe in the enterprise. And you know, those are very different things. We're not, there is no ABA. It's just a voluntary association, and I think that's why you don't want another accreditor for the reasons that Tom mentioned. But that doesn't mean you shouldn't take your argument to the states that, like California, you don't need to be an ABA. You can read for the law in California and take the bar exam. I'm in favor of that. I'm not in favor of letting anyone who wants to say they're a lawyer be a lawyer.
I just want to add, speaking only for myself, you know, Clark mentioned that Minnesota has moved towards allowing graduates of unaccredited schools to become a member of our bar if they've been a member of another state's bar. And I thought that was a positive development. I was speaking for myself, I thought that was a great move. But I will say this, a lot of state Supreme Courts have been debating exactly what Dean Yellen's been talking about. I mean, there's been some correspondence back and forth, and, you know, judges and justices are not very innovative. We rely on the inputs that we get from everyone else. And so there really isn't. I mean, people are happy with the status quo. And so I think a lot of the change, I think your instincts may be right, that a lot of the change will have to be driven by law schools and sort of ordinary lawyers. I'm not sure that the state bars or the state Supreme Courts are going to be driving the change, because I'm not even sure most justices understand the intricacies of the accreditation process.
I'd just like to add one thing, even though I am a Clark Neily. I want to confirm a point that Roger made. As a working public interest lawyer, I get dozens of phone calls every year, maybe more than that, from people who have legal problems, serious legal problems, that my organization, the Institute for Justice, will not be able to handle for them on a pro bono basis. And it is heartbreaking to have to suggest to those people that they go out and hire a lawyer to take care of that problem, because almost without exception, there is no possible way that they're going to be able to afford that. And nor would it really make sense in a lot of cases. Maybe there's $10,000 or $15,000 on the line, and they're going to burn through that in their retainer fee. And so I don't know whether there's too many lawyers in this country or not, but I can absolutely assure you that there are an extraordinary number of people with legal problems that are either going unmet or are being handled by them pro se, that could be handled by a lawyer who does not need to have graduated, with a deep understanding of jurisprudence, but just knows how to file things on time and not mess up basic concepts. I don't think we have a production system that's calculated to turn out those kind of lawyers, and boy, do we need them.
Let me I'd just like to say one word about conflation that's going on. Access to justice is an enormous, enormous problem in our society, and law schools cannot handle it on their own. In the studies empirical studies that have been done with things like advice-only programs at courts and low-level courts, helping people file responses to landlord-tenant actions, just simply file a paper and not fully represent the person, what they show is that the outcomes are no better than if the people are pro se. That the only difference in outcomes comes with somebody who is actively engaged in the representation of those claims. Now, whether or not that has to be a lawyer, as we have defined that, or we can creatively develop other groups, paralegals in a different model than we've thought about, paralegals who can provide advocacy in those situations. I think those are challenges for all of us to take on together about how to address this access to justice problems. And I know my law school would jump at the chance to do that.
All right, let's move on to the next question.
I'm Jay Schweikert. I'm a law clerk. I'd like to follow up on something that Dean Yellen just said. You suggested that the question of whether we should have more liberal licensure schemes is separate from accreditation. But with respect to, I find that a bit disingenuous, because insofar as legal profession is a coercive monopoly, the ABA's accreditation is a coercive accreditation standard, which is to say there's no other option. So it seems like they are very intricately related questions, and if we're going to maintain a legal monopoly, then we do have to be concerned about whether accreditation is really necessary. So let me put the question this way. If we were, hypothetically, to make accreditation voluntary, that is, keep it as it is, but allow clients to hire lawyers who went through alternative education systems, do you expect there would be clients willing to pay for and firms willing to hire such lawyers? If so, what does that suggest about whether accreditation is whether it's really necessary to ensure competent attorneys? And if not, why keep it coercive in the first place?
Well, again, I think you're asking several different questions. One is, would people hire untrained lawyers? I think absolutely. If, I've done a lot of criminal work. If there are a lot of jailhouse lawyers who do it for free, right? And some of them aren't bad. If they could charge, $25 or a pack of cigarettes, actually earn some money for doing criminal defense work, of course they would, and people would hire them. Whether that's a good thing or not is really not an accreditation question, it's a licensure question. Does the state of Minnesota care that people, go to an ABA accredited school? The ABA has absolutely no authority except that delegated to them by the various state Supreme Courts. So, as I said, California, you can read the law and take the bar exam. You can go to Concord Law School, which is an online law school, and take the bar exam. California has decided you don't need to go to an ABA accredited school, but you do need to still take the bar exam. If a state wants to go further and say you don't need to take the bar exam, I'd be very interested in the results of that experiment. I wouldn't be opposed to it, but that's even in my limited hat as an ABA volunteer, it's not something the ABA has anything to do with. It's the states.
Yeah, I think the point, we've made the point a couple times, but just to say it once more, there is a question about what tasks should be limited to lawyers. And many of us have been arguing for years that that could be zero or at least a very small collection of functions. I mean, I agree with Roger Pilon that you could easily go that direction. But that is a separate question from the question of if something is reserved to somebody who has a law license, such as appearing before a court, for example. Even there, you could have non-lawyers representing people in small claims court or lots of other courts. But assuming you've got a category of things limited to lawyers, then the question becomes who is a lawyer? And assuming law school is part of that, then the accreditation issue comes in. And that's really what we're focusing on here.
I'd like to emphasize something. The question here is not should we have lawyers or not lawyers. The question is not whether we should have ABA accreditation or no accreditation. It's, is there room in the legal profession for the effective equivalent of Walmart lawyers alongside Neiman Marcus lawyers? And the answer must be yes, but we're only going to get that if we experiment with non-ABA accreditation. By the way, you saw me maybe shuffling around up here like any good litigator. I have my materials with me. Interpretation 606-5 of the existing ABA standards says that a law library core collection shall include all reported federal court decisions, all federal codes, all state codes, and so on and so on. In physical form? Really? And this, I'm not pointing this out for the first time. People have been pointing this out for 15 years. And if the ABA still hasn't gotten on board that we're at a different place in legal education, again, this is just one example. I got dozens of pages here. Then I think there's more than ample room for another body, and they haven't earned their place where they are. That's the bottom line. Haven't earned the place.
Let me just say something about experiments with not having an accreditation system. Many of us at our law schools and many of us who've been involved in the accreditation process get multiple visits from high officials in legal education and the legal system throughout the world. Our legal education system is looked to as by far the best, by far. And they're looking to an accreditation system to keep it that way. Particularly as many countries look to expand access to their legal professions, they're looking to an accreditation system. So it can be a country in Africa, it can be a country in Asia, in many places around the world to create a better legal education system.
And if I could add just one other quick thing. You know, California is partly the model that you're talking about. There are thousands of lawyers in California who didn't go to an ABA accredited school. And that's fine. If my state Supreme Court asked me my opinion, I would say that people from other than ABA accredited schools should be allowed to take the bar exam. And in effect, then, you know, we'd have to compete with them for quality versus price. But in California, you know, nobody who gets into Stanford or Berkeley or Santa Clara chooses to go to one of the unaccredited schools because accreditation signifies a degree of quality that the market puts value on.
We have time for one more question. My apology to John and Tawan and everyone else who's in line, but one more question and then they're going to kick us out of this room, I think.
Right. I think there's an intrinsic value to attending law school. However, the average cost for a student is $100,000 right now. So I think it's fair to say that the average graduate wants to get a job. The average statistics are there are 45,000 graduates each year and 30,000 jobs created, leaving 15,000 graduates in the cold. And we can talk about like having more low-cost lawyers, but there is a significant number of law students who have no jobs right now, even if they are legal graduates. So I'm wondering how the ABA in good faith can continue to accredit law schools when there are actually barista attorneys who are graduates who have never been able to be employed as a lawyer because there simply are not enough jobs for them.
Well, okay. I think that's a funny question coming from someone at a Federalist Society meeting. Because you described the statistics pretty accurately, although I'd say the number of jobs available has gone down dramatically the last few years. And although there are projections that that will continue into the future, we don't really know what the future is. But as long as there's adequate disclosure of the results of people who graduate, as I said, I'm very much in favor of, who's the ABA to tell some school that although you provide a high-quality education, you've got to close down or shrink your class even though people want to come because we think the job market doesn't support it? I would think this group above all would find that that wasn't an appropriate role for an accreditor.
One dimension of this that I think may be worth mentioning, there are a number of profit-seeking pools of financial capital that are either buying law schools or starting law schools these days. That's fine. I'm not objecting to that at all. But and those will discipline the university-based law schools in cost and quality and everything else. That's all to the good. But the question, what we have to assume is that those law schools are going to have less incentive to see a kind of public serving and rule of law based component to their operation. And I think that it all ties into the kind of question you're asking. What is the future of the system we call legal education going to look like? Is it going to retain the capacity to help advance the quality of law, our sense, understanding of government, or isn't it?
I want to thank everyone for coming, and I think we owe a round of applause to our excellent panelists.